changes to or amendments to the property management regulations. Now, this came out in one of the property managers' newsletters last week. So, guys, I know I keep saying it. Every week that I'm talking to you, it's about making sure that you are linked in to receiving the newsletters from Fair Trading. There's Property Matters, there is Letterbox. If you are a property manager, you need to get both of those to give you the information that you need. So what came out with the amendments to the property management regulations, it's section 37.5. I'm pretty sure I'll just double check that. I've got it in a piece of paper in front of me here. So it's actually looking at if the state, territory or country in which the landlord ordinarily resides changes, to give the tenant notice in writing of the change within 14 days. So this is now a requirement that, and on the standard form of lease, which forms a part of the regulations, it now has. Remember, we've been talking week in, week out about the fact that the landlord's details, contact details, some form of contact needs to be a part of the lease. That's usually an email address or, depending on what it is, even if it must be provided for landlords, whether or not there is a landlord's agent. So it doesn't matter if you as the agent are managing this, the landlord's contact details still need to be on your lease. Now, also on there is, if not in New South Wales, you need to insert onto your lease the state, territory or country, if it's not Australia, that the landlord ordinarily resides in. So you actually need to put that in there. So, over time, we have also discussed the jurisdictional issues about taking matters to NCAT, and remembering that NCAT can only hear matters that are when the landlord and the tenant are both in New South Wales. Now, there's some exemptions to that when it's from a territory, as in ACT or Northern Territory, or when the landlord actually lives overseas. But when there's different steps to go through, and it actually needs to go to a court, not to a tribunal, therefore meaning that you as an agent will need to get, and obviously on behalf of the landlord, need to get legal advice on that. Some landlord insurers cover for that, some don't. So again, it's about, if your landlord does live outside of New South Wales, they need to check their landlord insurance policy. Firstly, you need to strongly suggest to them that they should have landlord insurance, and making sure that it covers the fact that if there is a jurisdictional issue, that is, a matter cannot be heard in NCAT, then their landlord insurance will cover taking it to whichever court, whether it's the local, the district court that they need to take that to. Obviously, that depends on the quantum of the claim. So, guys, there's just some it seems a minor change, but it's actually not, because the impact of that change within your residential tenancy agreement, when you are actually filling in those lease documents, that you actually need to be aware that you have to put down what state or territory that your landlord lives in or generally resides in. And if that changes, you actually have to make sure that your tenant knows about it, is notified of that change. So it's taking a whole lot of the uncertainty out of what happens when it goes to tribunal. So, and taking out some of the arguments about can it be heard, can it not be heard, and seeing where that actually fits in.